You will also have my contact information at the end, and you can feel free to contact me after the session. Osama bin Laden was the son of the Saudi elite whose radical, violent campaign redefined the threat of terrorism in the 21st century. Was referring to Osama bin Laden, the individual, and not necessarily to the entire Saudi elite, right? Which may be a much broader spectrum. Okay, but before that, so we have a cast of characters and a statement of what each side is going to do.
The subject of the contract, actually.
Pardon me?
The subject matter of the contract.
The subject matter of the contract is going to be in the duties.
Consideration.
Consideration, okay. And if a guarantee is not fulfilled, what does the other party want to be able to do?
Remedies.
Okay, before we get to remedies, we don't even get to what we think of as remedies, damages and things like that, right? We don't have to perform. And what do you want the remedy to be for that particular bad stuff? Conditions and covenants and remedies. You don't have to write it down. In every civil code jurisdiction in the world. Why? Because Napoleon decided, or his advisors decided, or his legislators decided, everything you should want to know about contracts, as well as the basic governing behaviors of human beings. Why does that contribute to laziness? Or, why does that contribute to misunderstanding of an American contract? You don't see in an American, or British, or Canadian, or Australian, or New Zealand contract, ask a question. You don't have to know the answer, but you've got to ask a question. Right? That's our primary job as lawyers, is to ask questions. How about this one? Even simpler. There shall be no modification of this contract except in an instrument with the principle of buyer beware. And that is a guiding principle in all common law jurisdictions. And your job as their lawyers, how can I reduce that risk? Right? Violations of contracts, breaches of contracts, does not mean we wind up in court yet. Some third party that could prevent the sale of that asset for some reason because of a pre-existing contractual relationship between the seller and that third party are sold to consumers who have no bargaining power, who aren't represented by lawyers. So the state legislature is actually the... Technically, the entity does not have legal capacity, and that would be the argument. That would be the argument that there are no claims that could conceivably affect seller's ownership or control over the right to sell. You got to know that those chemicals aren't spilling all over the ground, that those chemicals are safe to use within the permitted regulations regarding the use of that noxious, and it doesn't really express what the parties intend. So, short sentences. So, identify and explain what's unclear about each of the following provisions. Okay. If you're the buyer, do you want to take the suitcase? Not because you think there's any criminality. Okay, let's look at B. The unless and until terminated by 1 year's prior notice in writing. Upon the expiration of the initial term or any renewal term, right? Okay, if I'm going too fast, slow me down. Yes, anytime prior to the expiry, you could say that. Not that it occurs. We don't have to win every point. We just have to make sure our client understands what the problems are. Must is an obligation. Shall is an obligation. Not entirely clear. Okay, and E.
So the substantial agreement is reached, but there is an agreement to agree. It's not enforceable.
If there's an agreement to agree on what? Specify the number of units of seller's oranges on that date for a purchase price that buyer and seller shall agree in advance. That's a problem. But failing which agreement, whether by a court, by an arbitrator, by the parties themselves, which is really what you want, in your deal. So good. It's good that you asked that question. Okay. Now we get to a fun one. the the openings through which they could shoot were very narrow. You can say prior notice to borrower. You know, you can play with it a little bit. You want to do it in 24 words?
What shares?
What shares? Good, not properly described. What else? At what date? Also not set forth.
How many?
That's correct. It doesn't say how many. We think it must be because
No,
why would
no,
anyone
no.
hire a lawyer to do a deal when the whole deal is $200? Right? But we don't know from the contract. Yes, you picked them all up. That's exactly right.